Welcome, everybody. We're really excited to have you in class today. For this fun day session, this Friday fun day session, we are having the great honor of having Professor Amar, Akhil Reed Amar. He's a Sterling Professor of Law and Political Science at Yale University, and he's joined today by our CEO and President, Jeffrey Rosen. So a little bit about Professor Amar, and then we're going to dive into the Bill of Rights and these great stories that we're going to hear today. Professor Amar's work has won awards for both the American Bar Association and the Federalist Society, and he's been cited in more than 40 Supreme Court cases by the justices. So imagine that, students. We have so many students coming in today. Imagine that one day you could be cited like this as well. Now, a couple things that you want to know is that his new book, The Words That Made Us, America's Constitutional Conversation 1760 to 1840, will be released May 4th. And Professor Amar just launched a new website called akhilamar.com, which features a huge range of assortment of free downloadable articles, op-eds, and video links, perfect for all of our teachers out there. And he hosts a weekly podcast, America's Constitution. I will put this all in the chat and send it to you after class. But without further ado, I'm going to turn it over to Jeff Rosen. Jeff, I know the kids are going to have lots of questions, so they'll make sure they put them in the Q&A and the chat for us.
Thank you so much, Curry, and welcome, Professor Amar. Friends, I am so excited to share Professor Amar's wisdom and brilliance with you. He was my great teacher in law school, and it was Professor Amar who kindled my love for the Constitution, and all of the passion that I have in trying to inspire you to learn about it originally came from him. So he is America's greatest teacher of the Constitution. His books are invaluable sources of light for, and I hope all of you will read them, including his path-breaking new book, The Words That Made Us. And welcome, Professor Amar. We're so honored to have you here. Let's jump right in.
It's great to be with you, Jeff.
It's a precious time. We have about a half hour, and what I would love you to do, Professor Amar, is distill the essential principles of the Bill of Rights for our friends. And let's begin with the text. You taught me always to begin with a careful attention to the words. And you have taught us that the Bill of Rights refers repeatedly to the people. It talks about the right of the people to be secure in their person, houses, papers, and effects in the Fourth Amendment. The Second Amendment talks about the right of the people to keep and bear arms. What is the significance of the right of the people, and why did the framers choose that phrase?
Because, to borrow a phrase that came from the people, I just saw someone posting something that said, we got to stop worshiping the Constitution. It's not perfect. That's right. It wasn't perfect from the beginning. A lot of people opposed it. They were called anti-federalists. And here's the thing, and maybe close to half the country opposed the Constitution. And they opposed it in part because they said, dudes, you forgot the rights. Smart people at Philadelphia, right opposite the National Constitution Center in Hamilton, others, they came up with a document, but it wasn't perfect. They actually forgot to specify a bunch of rights. Ordinary people in the ratification process debated the thing. That's why the preamble says, we the people of the United States do ordain and establish. It was a deed, a doing, a constituting, an ordainment. So we talked about the thing, we the people up and down the continent, and maybe the first thing that many people said is, you forgot the rights. The Constitution was crowdsourced. In that process, several of the leading Federalists in effect pivoted. They said, okay, if you say yes, we'll try to fix that in round two. And we call that about the right of the people to assemble, because it came from people assembling in conventions, deciding whether to vote yes or no. It's not a surprise. It talks about rights reserved and retained by the people in 9th and 10th Amendments, because some of those rights are the rights to amend the Constitution, to change it, because it isn't perfect. It talks again and again about the people because it came from the people, from the ratification process.
Wonderful. Thank you so much for reminding us of that central importance of the phrase the people in ratification, and also for teaching me and others that in referring to we the people of the United States, the framers led by James Wilson had a radical idea that power resides in the people of the whole United States, not in the king and parliament, not in the sovereign or in the courts or Congress, but in we the people. Professor Amar, how would you like to group the amendments of the Bill of Rights? We have 10. Should we think of them as 10 individual amendments or as different sets of groups of rights?
I think you could do it either way. A really great maybe piece of music. I think you can listen. I'm a big fan of Hamilton, for example. You can listen to the whole thing, or you could have favorites. Oh, I like this one. I happen to like the intro especially, but Hamilton as a musical, which by the way, our mutual friend Neil Katyal introduced me to, I think works brilliantly both in the individual pieces and as an ensemble, as an organism. I might say, well, the First Amendment, which actually talks about Congress, is about expression rights. And the second and third are really about initially the military. Then there are a cluster of rights about beginning with, especially with the fifth about procedure, ninth and 10th are about rights of amendment and rights reserved and retained by the people as a whole. The Fourth Amendment is maybe its own thing. Okay, that's one way of grouping it, but here's a different way. After the Civil War, they group things really differently. They say, oh, Second Amendment, you need a gun in your house to protect yourself. Oh, the Third Amendment, the government shouldn't invade your home. Oh, the Fourth Amendment, it's about the right to be secure in your person's house, your house, papers in effect. So different generations might look at the document and actually organize the amendment. It's got speech and press over here. It's got religion over there. At the founding, that was because these were two areas that were left to states to regulate. Congress shall make no law. Why do we know that that was a states' rights provision? Because when we look at state constitutions, expression and religion aren't yoked together. So at the state level, there's religion rights and there's expression rights, and they're not combined. The First Amendment says they are together because these are domains over which states originally were supposed to have authority and not the federal government. Oh, but after the Civil War, we look at it and we see a completely, we organize it differently. We see different connections. We say, oh, speech and religion are connected because religious speech is important. And religious speech is not completely different from political speech. The most famous speaker in the 1850s, Harriet Beecher Stowe, writes a book, Uncle Tom's Cabin. It's religious, it's artistic, it's political. It's all in one. So after the 1850s, people start to say, oh, religion and politics, religious speakers, those are important. So there are different ways of looking at it. It's a great piece of music. One of my friends, Bert Newborn, actually has a book about the Bill of Rights as a kind of piece of music, and he organizes it kind of in his own way. So a really great piece of music, you could play it different ways.
Wow. Friends, did you hear the many important insights that Professor Amar just shared? First, he told us that at the time of the framing, you could think of some of the parts of the First Amendment, for example, as a protection for states' rights against the federal government. Congress can't establish a national religion in order to protect the state establishments from being disestablished. Professor Amar taught me that fancy word, anti-disestablishmentarianism, which comes from his great insight that the amendment might have been a federalism provision at its outset. But then he tells us that at the time of the Civil War, the collective rights of we the people were glossed in a new way as rights of individuals, the rights of individual African Americans to protect themselves against mob violence after the Civil War, the rights of African Americans to read and to challenge as unconstitutional the laws that forbade them from going to school. This was Professor Amar's great insight that the Bill of Rights can mean different things at different times. So what is the consequence? Our friends are really interested in different methodologies of interpretation. If someone cares about the original understanding of the Constitution, should you view the Bill of Rights as a collective protection for the people or individual rights for citizens after the Civil War? How are we supposed to make sense of that change in understanding?
I would say it's both, but because it's really important, if you just start with the Bill of Rights, it talks about, as Jeff said, the rights of the people, as in we the people, and the most important right of all, probably, is it? It's so important that one of my best students of all time wrote a student note on this topic, the inalienable right of the people to amend the document. Jeff is smiling because he was that student. That was his note at the Yale
You're just being nice.
Journal. It's really important. No, it's a deep idea. It's what the 10th Amendment and the 9th Amendment are about. Those are the most important rights retained and reserved. They're not just reserved to the states, they're reserved to the people in the 10th Amendment, as in we the people. So if you believe that, just start with the Bill of Rights. It says, pay attention to we the people and the amendment process. And then if you understand that the Constitution really was really importantly amended, a second founding, if you were, after the Civil War. And that's been a huge theme of the National Constitution Center, especially under Jeff's leadership, is focusing not just on the first founding, which includes the Bill of Rights, but the second founding after the Civil War. Then you can't ignore that. You can't ignore the ways in which the 14th Amendment invites us to take a second look at the Bill of Rights and see things that maybe weren't originally there, but actually are part of the amendment process, because the 14th Amendment interacts with the early amendments and creates new patterns and meanings. And that's one way of understanding. There's several ways of understanding an interactive constitution. And the National Constitution Center has this amazing website in which you can interact with the Constitution, just ordinary Americans, 7th graders, 9th graders, what have you, is interactive. Later amendments actually connect up with earlier ones and create new patterns of meaning, of original intent, because you have to take seriously the original intent of the amendments as well as the original intent of the earlier document.
That's one of Professor Amar's many great contributions to our understanding of the Constitution. He inspires us to read the document as a whole, to read subsequent amendments like the 19th Amendment, and then gloss earlier amendments through them in a process that he has called intertextualism. It's a wonderful way of looking at the Constitution to see the ways different parts of the text connect and influence each other over time. One of our friends asks, Ken Brown says, did the founders set the bar to amend too high? And another of Professor Amar's amazing contributions was his argument early on, around the time when I was studying with him, that it may be possible for we the people to amend the Constitution outside Article 5. If the right to alter and abolish government is an unalienable right that comes from God or nature and can't be alienated to government, Professor Amar has argued, then Article 5 may not be the only way of amending the Constitution. I know you've had some subsequent thoughts about that incredibly important argument, but tell us more about it and whether you think that the bar to amend is too high.
I may have changed my mind on this just a bit. When I was a young man, I said, oh, things could be so much better. It's too hard to amend. And now I'm a much older man. I still have long hair, but I'm a much older man. And I think, could be a lot better, but maybe it could be a lot worse. So here are the two insights I've come to have as I've continued to study. One, although we haven't amended the document very much, 27 amendments, and the first 10 were kind of a cluster. So, 17 or so episodes. And you could even say, actually, they came in clusters. So 13th, 14th, and 15th is a cluster. And in the 19 teens, there was another cluster. In the 1960s, there was another cluster. So maybe only 4 eras, moments, if you will, of real amendment energy. The founding, civil Reconstruction, 19 teens, 1960s. That's about 95% of the text. So even if you say that, okay, 4 out of 200 years, that seems not very much. But almost all the amendments have been good ones. But we quickly got rid of it. Now let's contrast that. So not so many, but all good. I come from California, lots of amendments. It's very easy to amend, some good, but actually some not so good. And in my lifetime, there were proposals to amend the Constitution that I think would have been really bad proposals, and they failed because the bar was set high. There was a proposal, for example, to put into the Constitution the idea it's a crime to basically criticize the government, to burn a flag. And that would have been a horrible thing to put into the Constitution. And actually, that's what Jeff Rosen's note was all about, how that would have been a horrible thing. But it didn't pass in part because the bar for amendment was very high. And I testified against that amendment. And Jeff was with me on that. So that was a bad idea, but the bar was set high and it failed. People said 15 years ago, 20 years ago, let's amend the Constitution so it constitutionally says one man, one woman only for marriage. Now, I think that would have been bad. It would have been a violation of liberty and equality to say that gay people can't be married if they love each other. So I'm glad the amendment bar was set high because that was a bad idea and it failed. So when I was young, I said, oh, are not succeeding, not clearing the bar. Now that I have a little bit more perspective, I say, maybe the bar is set about right. We have been able to amend when we needed to. We added a Bill of Rights. We had these amazing amendments in Reconstruction in the 19-teens, the 1960s. I'll say it one other way. It's not just me about California. I just invite audience members. You've got a state constitution, unless you live in DC. So we have 50 state constitutions and the federal. Your state constitution is easier to amend. Do you have more of an attachment to the US Constitution or your state constitution? Do you even know what's in your state constitution? And I would say most Americans probably have more attachment to the US Constitution, which is the one that's harder to amend. That's just
wonderful. And now, Jules Bernstein asks a really important question. Why do you think originalist philosophy has only been used by conservative justices? Can an emphasis on the framer's intent lead to liberal conclusions? And if so, why have liberal justices not adopted this philosophy in response to conservatives? In fact, Jules, Akhil Amar is the greatest advocate in America of a kind of liberal originalism. And he taught me when I was a law student that if you apply original understanding in a principled way, separating your political from your constitutional conclusions, then it should be just as likely to lead to liberal results as conservative ones. Professor Amar, I'm going to call you Akhil because, of course, I've called you Akhil for a long time because we've been friends. But I use Professor Amar because you are America's great professor of the Constitution. Akhil, give examples of places where you think the Constitution applied in light of principled original understanding can lead to liberal results. And you might even begin with the Fourth Amendment, where your scholarship has been so influential.
Thanks. Let me just begin with the Warren Court. It's seen as this liberal court, and you may have been taught the key people on the Warren Court were Earl Warren, maybe William Brennan, they're living constitutionalists. The driving intellectual force of the Warren Court was an originalist. He always carried a copy of the Constitution around with him. What an odd fellow to carry a copy of the Constitution around with him. His name was Hugo Lafayette, Black. And here's what the Warren Court did. And it overruled lots of precedents in the name of the Constitution itself. So here's what the world looked like before Hugo Black went on the court. The Bill of Rights, basically, which we talked about, didn't apply generally against states, but only the federal government. And Hugo Black said, but when you read the 14th Amendment, it's really clear that no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. And what are those privileges and immunities? things in the Bill of Rights: speech, press, free exercise, rights against unreasonable searches and seizures, and so on. So he says, it says in the document, apply the Bill of Rights against states. Let's do that. That's liberal originalism. When he's appointed to the court, there's massive segregation everywhere. And he says, but it said, Plessy is the law. Plessy versus Ferguson is the case law. He says, it says equal. Let's do equal. It says it, okay? And the Warren Court does that. When he's appointed to the court, there's massive disfranchisement in America, and almost nowhere is there, almost every place has malapportionment of a certain sort. Votes aren't counted equally. He says, it says right to vote again and again and again here. 14th Amendment, Section 2, 15th Amendment, 19th Amendment, and then in the 1960s, a couple more amendments. Let's do it. It says right to vote. At the time that he's appointed on the court, free speech had almost never prevailed in court. And he says, but it says freedom of speech and of the press. Let's enforce that. And they did, the Warren Court did, in landmark cases like New York Times versus Sullivan. He says criminal defendants had in court precious few constitutional rights. And he reads them and he says, actually, it says here that they're supposed to have rights. They're supposed to have rights even to counsel. Poor people, as a practical matter, don't have that because they may not be able to afford lawyers. Let's enforce what's actually in the document. The driving force of the most liberal court we've ever had, the driving intellectual force, was a liberal originalist named Hugo Black, actually. And so there are conservative originalists, Clarence Thomas, Antonin Scalia, Neil Gorsuch, others. There are those are conservative originalists. There are liberal originalists, yours truly, Hugo Black. And I do think, yes, sometimes Jeff and I, when we were scholars, now he's nonpartisan, said, you know, Roe versus Wade, there are some questions. It's complicated. The Constitution may not lead to every liberal result that you happen to believe in politically. But Jeff said it just right, and that was before he was on the National Constitution Center, just writing as a scholar, but Jeff put it right. Constitution honestly applies, lead to liberal results. I'll say one thing, it often leads to wise results because it's the product of many minds over many generations. There's a wisdom of crowds that the Constitution distills. It came from we the people, it's been amended by we the people, bottom up, crowdsourced. And even if you're not bound by it, if you don't want to be bound by it, study the history, study the text carefully, because you can learn from it. It might persuade you of certain things. It's wise, maybe even wiser than Shakespeare. You know, it's maybe wiser than the wisest person you will know, because that's only one person. And this collects the wisdom of an entire people over many centuries.
Wow, that is so inspiring. I haven't heard you put it exactly like that. I'm so glad you shared that inspiration with our friends. Christopher Dugan says, can you talk a bit about how the court has ignored the intention of the framers, especially in the Dred Scott and the 14th Amendment, the civil rights cases, and Plessy? You and I were in a wonderful discussion last night, sponsored by the New York Historical Society, and you made a brilliant point that just took my breath away, because of course I hadn't thought of it, because it was your insight that it's possible that the City of Burney case, which struck down the Religious Freedom Restoration Act, might be re-examined by the Supreme Court. And if that's wrong, then that suggests that the Shelby County case restricting Congress's ability to protect voting rights was wrong, all suggesting that there was a sort of wisdom in the original understanding of the Reconstruction framers to give Congress broad authority to protect equality and religious liberty. So say more about that, how the Supreme Court got it wrong, and how the Constitution, properly interpreted, wisely would have gotten it right.
First, let me give a big shout out to my friend Chris from Boston. He is thanked by name in the acknowledgments of my new book. He read early chapters. He's an expert on James Otis. Since Jeff mentioned the Fourth Amendment, chapter 1 is all about James Otis, and Chris is a lawyer up in Boston in the James Otis tradition. He's actually established a lecture series in James Otis's name, and so Jeff's name appears on the back of the book because he very kindly said some things about the book as a blurber, and Chris Duggan's name appears inside the book. He's one of a few people especially thanked, and he who take rights seriously, as did James Otis, as does he every day in general. And so, yes, I think that the document itself is often wiser than the cases. So Dred Scott made stuff up, and the document, and that's why Lincoln, appealing to the document, called Dred Scott an astonisher in legal history. Now, the Constitution wasn't perfect on slavery, but because of amendments were added to the document, the 13th, 14th, and 15th Amendments, and they all ended with the same phrase, Amendment. It begins, Congress shall make no law. But the Reconstruction Amendments all reverse that. They all end with Congress shall have power. And remember what I told you before, the Bill of Rights originally came from the people. So did the amendments, but the amendments in particular came from Congress. Congress proposed the 13th Amendment and the 14th Amendment and the 15th Amendment. These amendments came from Congress. They specify that Congress shall have power. And if all of that is right, and I think it is, then congressional power to enforce rights in Section 5 of the 15th of the 14th Amendment, or Section 2 of the 15th, Section 2 of the 13th. So Chris and Jeff and I are all part of a tradition that takes really seriously the text of the Constitution, that thinks it's wise. One of its real fonts of wisdom is Congress can play an important role in protecting rights. Courts aren't the only ones that can play an important role in protecting rights. And the idea of the National Constitution Center is not just Congress, not just courts. Citizens can, when they're voting, when they're on juries, in other contexts and capacities, when they're serving in militias. And you're not going to be able to quite discharge all of those rights and responsibilities if you don't know what's in the Constitution. And that's why the National Constitution Center is so important. And that's why I hope, if you're at all interested, you check out the website that I've got, akhilamar.com, or the new book, The Words That Made Us, because they're designed for ordinary citizens to learn more about their rights, because you can't just trust the courts. I agree with Chris about that.
I am going to ask about the Fourth Amendment again, just because you're so inspiring when you tell the story of James Otis. And in your new book, The Words That Made Us, you explain with such brilliant technical precision the way the framers saw a difference between writs of assistance and general warrants. One instrument of tyranny was considered even worse than the other. And this influenced both the American Revolution and their conception of what the Fourth Amendment was originally meant to protect and what it protects today. So give our friends just a hint of all the wisdom that excavation of the original understanding can cast on the Fourth Amendment.
In a nutshell, I'm pulling everything together. The Fourth Amendment, Jeff asked at the very beginning, mentions the rights of the people. So does the first, the right of the people to petition and assemble. And the 9th and the 10th are about rights reserved to the people. The second is the people mobilizing in militias, the right of the people to keep their arms. But the second says the right of the people to be secure in their persons, houses, papers, and effects. Now, you might think Fourth Amendment is very much about privacy, about my person, my house, my private domain. So what does that have to do with the people? And here's what it does. At the founding, juries played a really important role in protecting individual privacy rights. When someone was intruded upon by government, a person could go to court and a jury could decide whether the government was acting reasonably or not. It was a jury, ordinary people playing a role in rights protection, just of the sort that we've been talking about. Now, it turns out that the writs of assistance were bad, but they weren't horrible the way general warrant. They could just intrude upon you, and no matter what, you had no recourse because they say, we have a warrant. But when they had this more technical document, this technical piece of paper called a writ of assistance, if they broke into your house unreasonably, on a whim, just because they don't like you or your politics, your religion or whatever, and they found nothing because they're likely not to find anything if they're just doing it to punish you, you can sue them in court and get a jury of your peers to say that was unreasonable, and it could reward you with damages and discourage the government, deter the government from doing that again. So that early case that Chris loves James Otis and the writs of assistance. It turns out, even though not everything that James Otis said was maybe perfect, that case was all about the rights of the people, all about the rights of jurors, ordinary citizens, but you're not going to be able to do any of that unless you spend time at the Constitution Center, visit the Interactive Constitution, a book about the Constitution, maybe one that I've done, maybe the most recent one, which I think is my best and most accessible one. But you can't do any of that unless you actually are an active citizen.
One of your extraordinary contributions is to help us think about the criminal procedure amendments in a new light. And you have argued that the 4th, 5th, and 6th Amendments are more about protecting the rights of the innocent rather than the guilty. Tell us about that and what the consequences are for constitutional law.
If you think that the 4th Amendment is just about the exclusionary rule, that if they break into your house and they find stuff that shows that you're guilty, but they broke in improperly, you can get the evidence excluded. If you thought that, well, then it would be, and that was the only remedy you had, it would be open season on innocent people. They know Amar's innocent. They're not going to find anything, but they break into his house anyway. They strip search him. They rough him up a little bit. They ransack the place. Well, if the only thing that you had was exclusionary rule, they didn't find anything in my house. But if the 4th Amendment is really about especially protecting innocent people, then when they don't find any stolen goods in my house, any smuggled goods in my house, I can sue them, and a jury of my peers, and now we're back to the Otis and the writs of assistance, could say, gee, that was unreasonable government conduct. And maybe the more innocent I am, the more sympathetic I'm going to be to a jury. And so that was the beginning of this insight that actually the 4th Amendment is about protecting at the heart innocent people in jury trials. The 5th and the 6th Amendments, rights of jury trial and public trial and speedy trial. The most important thing is innocently convicted. It's about the rights of innocent people against an overweening government.
I have to turn the mic back to Curry soon, but you know how reluctant I am to stop our conversations because there's so much light you have to spread. We've talked about the First Amendment as a protection for federalism. We've talked about the Second and Third Amendment as protections for the militia, about the Fourth, Fifth, and Sixth Amendments as devices for protecting the innocent. What do you want to tell us about the ones that we haven't focused on yet, the 7th, the 8th, the 9th, and the 10th?
Well, the 7th is about civil juries that are going to play a big role in enforcing searches and seizures. The 9th and 10th are about the rights of the people. Most importantly, to amend the Constitution and keep it up to date. Even the 8th Amendment is in part special restrictions on bail and on criminal and on sentencing, because a judge in setting bail and imposing a sentence is typically acting on his own, now her own, without a jury to monitor. So if at the founding, wow, juries are everywhere. They help protect freedom of expression in the Zenger case. A militia is kind of like a jury, it's just local juries with guns in their hands, local folks, amateurs. The Fourth Amendment, the jury is going to protect your search and seizure rights. Fifth Amendment, grand jury. Sixth Amendment, trial jury. Seventh Amendment, civil jury. The jury isn't there when judges are sentencing. That's partly what the Eighth Amendment is about. So, but juries are about ordinary political participation, ordinary people. That's what the National Constitution Center is all about. The ability of ordinary Americans to play a role in constitutional conversation. Courts are great. I love courts. I think they're our least dysfunctional branch right now, but you can't count on you or to breathe for you, or to think for you. We can't just rely on courts. We have to be active constitutional participants ourselves. And that's why I'll just say one final thing. One of the things that I'm most proud of in my life is that I helped bring the National Constitution Center into existence. And I did it because, in part, when I was 10 years old, my parents took me to Philadelphia, took me to Independence Hall, and it changed my life. And so I love Philadelphia. I love the Constitution. I love the National Constitution Center. I was younger than most of even the fifth graders and seventh graders who are participating today. And when you grow up, if you want to be a constitutional law professor, oh, that would be great. But you're going to, no matter what, be voters. And I want you to do jury service as well. And you can't really do those things. Every 4 years you pick a president, that's a constitutional decision. You can't do those things well unless you actually think about this document. So Jeff, thank you. Jerry, thank you.
Thank you, Akhil. That was so beautifully said. And thank you for changing the life of your hundreds of thousands of students across America, including me, and for reminding us that only by paying close attention to the text of the Constitution, the words that made us, as you so beautifully put it, can we defend the liberties and understand the structural protections that make this wise document the force that unites us as a people. Curry, just a few questions for Akhil before we reluctantly let him go.
Yeah, so we'll get the student questions in real quick. So Nina asked the question, where did the idea of we the people come from? Were Native Americans, was it a Native American idea, or what was the genesis of those beautiful three first words?
So I'm going to say something that's not politically correct. A lot of folks have said, oh, we get these ideas from the Iroquois Confederation or something like that. It would be nice if it were true, but I think most serious scholars say, no, they're not coming from the Iroquois. That's what Jack Rakoff says. That's what Gordon Wood says, and I'm with them on that. Actually, those three words were penned by a Pennsylvanian, James Wilson. He was one of 6 people to sign, only 6 to sign his name to the Declaration of Independence and the Constitution. He was one of the greatest lawyers in America. Here's what I want you to know about James Wilson. He was an immigrant. Some of our great, so it's not quite perfect, maybe, in terms of a kumbaya story about inclusivity. It doesn't actually come from actually Native Americans, truth be told, in my view, but it does come from a great immigrant. And I'm a huge fan of Hamilton and both Alexander Hamilton and Lynn Miranda's Hamilton. Hamilton is another immigrant. So, and Native Americans are an important part of our constitutional saga, just probably not those 3 words, but those 3 words were written at Philadelphia by James Wilson. And you can see the draft of that of detail version of that. So it came from a Philadelphian named James Wilson, who was a great immigrant, one of the first 6 justices on the Supreme Court.
Awesome. Great. Okay. And then one last question, and this comes from our 6th grade class. They want to know, and this is a hard one to answer, what's your favorite amendment in the Bill of Rights? And we use that word very loosely. It can be just the one that you're most interested in, the one that you examine the most. So what's your favorite amendment in the Bill of Rights?
Well, why don't you ask me who's my favorite child? A nice easy thing. like that. Oh, you know, I do think that Jeff, way back when he was my student, and if you're really lucky, you learn a lot from your students. Jeff's brother-in-law, whom I've mentioned in passing, Neil Katyal, another one of my great students. 5 of my students are actually on the Biden Judicial Reform Commission. 4 of my students are senators of the United States. So I've learned a lot from my students, and from Jeff as much as any student I've ever had. And I think Jeff says in his student note that the most central ideas, the inalienable rights, the rights that are so powerful, you can't even change them, even if you wanted to, because they're constituent of all others, are basically the right of amendment, because you have to be able to change things, and the rights basically of conscience and expression. You can't give up the right to think for yourself. That's inalienable. You couldn't give it up even if you wanted to. You'd be selling yourself into slavery. You can't, and he's nodding his head because he's now remembering. So the right to think for yourself, to express things politically, and to change the Constitution, those, I think, are at a deeper conceptual level than everything else. That's Jeff Rosen's note, and I think he's right.
Absolutely.
And by note, I mean a student essay that he wrote. It's called a student note. And I think he was right.
I think that is a perfect way to wrap it up, to remember, to tell all of our students to think for themselves, and when they think it's necessary, make change. I think that's a great guiding principle of the Constitution and this lesson today. I want to thank you so much for this great class today. Jeff, thank you for guiding us through this deep conversation. And students, we so appreciate that you are a humble community of all ages and all learners with brilliant questions. Thank you all so much. Thank you, Akhil. Thank you, Jeff.
Thank you, Akhil. Bravo. Thank you, friends. Have a wonderful weekend. Thanks to Professor Amar. What a wonderful discussion.